Next, let's talk about expectation damages, which are the most common remedy if there is, in fact, a breach. When a promisor has not performed under a contract to any extent, it's a breach. And the most common remedy for breach that courts will provide to the promisee is called expectation damages. Expectation damages are designed to put the promisee in the position she would have been in had the contract actually been performed. Before we discuss exactly what that means, please be clear about how this concept of putting a party in the position they would be if the contract were performed is different from putting a party back in the position they would have been in if the contract had never been formed. Under tort law, and this is contracts class, but under tort law, if Carl wrongfully punches Danny in the face, damages are meant to restore the status quo, to move Danny to the position she was in before her nose was broken. The tortfeasor, Carl, would pay for the harm to Danny and put Danny in the position she was in before Carl broke her nose by paying money damages equivalent to her pain and suffering, and sometimes there's some punitive damages as well in torts. Contracts are not meant to work this way. Contracts are not designed to restore the status quo. Contracts generally do not seek to put a party in the position they would have been in had the contract never been formed. Instead, in contract, courts try to give the parties the benefit of the bargain that they struck, trying to put the person who was injured in the position they would have been in had the contract been performed. Therefore, courts use expectation damages to put the promisee in the position she would have been in had the contract been performed. Let's look at a famous case to illustrate the difference between expectation damages in contract law and status quo, or also referred to as reliance damages, that we would find in tort law. Hawkins versus Mcgee is the famous case of the hairy hand. In this case, the doctor performed an experimental skin graft operation that was supposed to remove a scar. And, perhaps unwisely, the doctor promised that the patient would get a 100% perfect hand as a result of this agreement. But that's not what happened. The operation failed. And instead, the patient ended up with a hairy, unusable hand. What is the correct measure of damages for this patient? Without using numbers, let's talk about it conceptually. Well, first, I'll tell you how the trial court got it wrong. The trial court misunderstood the contracts case as a tort case and improperly applied reliance damages to put the party back in status quo. At trial, the judge gave the improper jury instruction to award damages for injury to the hand plus pain and suffering. That would have been the correct damages for a case at tort, but it is not the correct damages for a case at contract. Why is this not correct at contract law? Because the trial judge sought to put the patient in the position he would have been in had the contract never been made. The damages measured by injury to the scarred hand plus pain and suffering would be sufficient to put patient in the status quo, but would not give the patient the benefit of the bargain. The patient bargained for a 100% perfect hand and ended up with a hairy, unusable hand. The appellate court held that the trial judge should have instructed the jury to award damages as measured by the difference between the hairy, unusable hand that the patient ended up getting and the 100% perfect hand that was bargained for. That's the difference between the value of the bargain that would have happened had the contract been performed and what actually happened as a result of the breach. Now, let's talk less conceptually, more mathematically about how to calculate expectation damages. According to the second restatement of contracts, section 347, the injured party has a right to damages based on his expectation interest as measured by, and I have it here on the board, A, the loss in value to him of the other party's performance caused by its failure or deficiency, plus B, other loss, including incidental or consequential loss caused by the breach, less any cost or loss avoided. that was avoided by not having to perform. So we have a formula that we can write out as loss in value plus other loss minus loss avoided equals expectation damages. Let's use a simple hypothetical to try out the formula. Sony Television agrees to sell a television to Best Buy electronics retail store for $500. And Best Buy plans to resell the television to consumers for $700. That would be a profit of $200. So what is the benefit of the bargain that Best Buy expects? A $200 profit on these simple facts. If Sony breaches before Best Buy pays for the TV, what are the damages? Well, it's not $500 to rescind the transaction and put Best Buy in the position it would have been in had the contract never been made. No, it's to get the parties in the position they would have been in had the contract been performed. So expectation damages on these simple facts are $200, which is the amount of profit that was not obtained because the contract was breached. How is this different from Reliance damages? To be clear, since Best Buy did not pay for the TV and did not receive the TV, then Best Buy is already in a status quo position. They didn't get what they bargained for, and they didn't pay for it. So they're already in the position they would have been in had the contract never been formed. But if this were the measure of contract damages, then parties could easily breach. Instead, we hold Sony responsible for the expectation loss of $200 in profit. What are some types of other loss? Consequential and incidental damages. What are consequential and incidental damages? The restatement says that incidental losses include costs incurred in a reasonable effort, whether successful or not, to avoid loss, as where, for example, a party pays brokerage fees in arranging or attempting to arrange a substitute transaction. Costs incurred in arranging for a substitute transaction are a type of incidental loss. And consequential loss includes such items as injury to a person or property resulting from defective performance. So how would these losses come about in the simple hypothetical I presented? Incidental losses are incurred in arranging a substitute performance. Let's imagine that the Best Buy customer is justifiably angry because a TV will not arrive in time for him to watch the Super Bowl. So the Best Buy manager drives 100 miles to get a replacement TV from another location. The cost of the manager's time and gas is incidental loss. How about consequential loss? Well, let's change the hypothetical a little bit. Sony delivers a TV to Best Buy, but the TV is defective. And so when Best Buy plugged it in on their display wall, it catches on fire. And it damages the Best Buy store to the tune of $1,000. The consequential cost, the consequential loss of $1,000 in fire damage as a result of selling a defective television will be added to the damages that Sony must pay. They are losses such as injury to person or property resulting from the defective performance, here the defective performance being a TV that catches on fire. How about loss avoided? How can a breach result in loss avoided, which is deducted from expectation damages? Let's change the hypothetical one more time. Sony fails to deliver an entire truckload of TVs to Best Buy. So Best Buy has no TVs to sell at its big Super Bowl television sale. As a result, Best Buy does not even bother opening the store on the Monday before Super Bowl Sunday. If Best Buy does not have to pay for electricity or does not have to pay its employees to work on that day, then those costs, which would have been incurred if it had televisions to sell, but it did not incur because it had no televisions to sell, must be deducted from the amount that Sony owes Best Buy. It is loss avoided because it didn't have to operate the store to sell the televisions. Finally, what type of loss is not included in this formula for expectation damages? Reliance damages are not included in this formula. What are reliance damages? Well, what if Best Buy spent $100 advertising the Sony TV sale? That is a change in reliance. They expected to receive the televisions, and so they spent $100 in reliance of that promise which was breached. Or maybe Best Buy spent $100 changing its shelving or its display unit to display this new television. Does that mean we add an extra $100 to our expectation damages? No. We don't add those reliance damages because they were baked into the bargain to begin with. Best Buy expected, in this case, to receive $200 profit from the sale and $100 expense, so it's not reasonable to give them that expense twice. Those are costs that Best Buy expected to spend. We do not add reliance damages to expectation damages. If you're confused, try to remember the key point that expectation damages are awarded to give the parties the benefit of the bargain that they struck. They are not designed to put parties in the position they were in before the contract was formed. Accordingly, reliance or status quo damages are an alternative, a minor alternative, but are not added in addition to expectation damages. So make sure to keep the concept separate. Next, we'll talk about efficient breach, which has been offered as an explanation of why courts prefer expectation damages. But before we go on, are there any questions about how to use the formula for expectation damages under contract law?